Okay, Ms.
Yes,
Chris?
Judge. I would like to begin by reading out a statement, please.
Yes.
The hearing today is in the matter of CFI 005-2021 before Justice Roger Giles and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Nimble Legal Consulting. Lead counsel is Hari Krishna. The defendant is represented by Curtis Mallet Prevoy, Cold and Muzzle. Lead counsel is Sophia Hurst.
Yes, thank you. Well, I have read the two affidavits of Ms. Burt, the 2 December affidavits of the claimants, and of course your respective skeletons. It would not be right to say I'm familiar with all the annexes and materials referred to in the affidavits, but I doubt that close familiarity is going to matter. I would like to put aside, at least for the present, the question of an unless order and really just look at what the problems are, if any, with the discovery as to each of the categories in turn and what might be done about it if there are problems. So I had in mind, subject to any thoughts that you both might have, that we would take the categories in turn. I would hear from Ms. Hurst, then from Mr. Krishna, and try and see where we stand on each category before moving to the next one. Is that a convenient course?
My Lord, I'm very grateful for that, and thank you. Your Lordship's obviously done quite extensive pre-reading. I'm happy to take the application as you suggest, subject perhaps to 2 points. In my submission, it's relevant, given that the order that you made was the 31st of August. In my submission, it's not simply a case of looking where we are now, but looking at where we were at the 15th of September, which was, of course, the date for compliance with the order. Because as you may have had a flavour from the 2 affidavits of Ms. Burt, we say that what compliance there has been late and drip fed, and so those were already breaches of your Lordship's order, and that those bits of piecemeal compliance, as it were only brought about by rather extensive correspondence from those instructing me, trying to explain why what was done in purported compliance with the order wasn't good enough. So what I would propose to do, if it's convenient to your Lordship, of course, is to show you where we were as at the 15th of September, and then explain why and to what extent we say those breaches haven't been cured. Would that be convenient?
Well, that does not involve putting aside the question of the unless order, because the relevance of that is the unless order, surely. Is it not better to look at where we are now and what, if anything, might be done about it, and then go back to whether what can be done about it might include an unless order?
My Lord, I can look at it in that way, and perhaps as we go, I can give you a flavour of how we've arrived there. The only point that I would stress by way of background, your Lordship obviously doesn't need to deal with in any detail at all the underlying claim, but I would just say this by way of introduction. The claim that's made is obviously a relatively straightforward contractual claim. The allegation is that certain sums were outstanding under the settlement agreements entered into at the termination of the claimant's employment relating to the business sale. Of course, we say that the defence and the counterclaim is not so straightforward, and those allegations consist, in very brief summary, of a defence along the lines that the sums allegedly payable to the claimants were only payable in circumstances where they weren't in breach of their obligations. And what's said by way of defence and counterclaim is that, in fact, there was an unauthorised and undisclosed scheme between the claimants for a management buyout, where they did not share with the defendant what they were doing, and in the course of that arrangement disclosed confidential information to potential third-party purchasers, causing loss to the defendant on the sale. That's a very brief overview, but I say that that is relevant for your lordship to have in mind, because of course that's exactly the kind of allegation where the defendant is at an information barrier, and by definition, if what's being alleged is an arrangement as between the claimants themselves, then she's unlikely to have the relevant documents. Those documents are far more likely to be held by the claimants. And I just ask your lordship to have that in mind as we go through the requests. I think perhaps it's convenient to start if we go to bundle in the bundle behind tab 11. This is the exhibit to Miss Burt's third witness statement, but at page 108, if your lordship could turn that up.
Yes.
Now, my lord, what this is the summary of what had been disclosed on the 15th of September under each request. Now, the reason I'm taking you here is because this is probably the most convenient table form, which shows you so that you can have in mind what the request was in the left-hand column. And then in the right-hand column is a summary of what was disclosed on the 15th of September. Now, obviously, I'll explain as we go how that's where we've got to and what's been disclosed since. But it's perhaps the easiest sort of visual summary of each of the requests. Otherwise, we'll be flicking backwards and forwards between documents. So, so far as we're concerned, standing here today, by way of very, very brief summary, there was obviously disclosure on the 15th of September. There was a period of correspondence between those instructing me and the claimant's former counsel. And pursuant to that correspondence, some further disclosure was forthcoming. The application was then made on the 9th of November, following amended document production statements. Those were filed on the 1st of November. And we say that notwithstanding those exchanges, at that point in time, the disclosure was still non-compliant. Then in response to the application, the claimants, rather than, it should be said, rather than actually responding to the application, requested a directions hearing. And at the directions hearing, their position was there was nothing further to be done and that their disclosure was entirely compliant. At that hearing, the registrar directed the two affidavits to be created by the claimants, which your lordship says you've read. And we do say that that's relevant because that was the first time that the claimants really sought to engage with, in particular, paragraph 1C of your order, which was to explain that if there were no further documents, what had happened to them, why there were certain documents which were no longer in their possession, custody and control. And we say that in brief, although there is now some attempt, and we say very belated attempt, to comply with that order in December, in fact, the terms of that evidence show that we think there are still significant gaps. And so with that very brief background in mind, I want to just look at each of the requests. So request 1 was for all of the correspondence between the claimants between the 1st of January 2017 and the 26th of July 2018 relating to the claimant's management buyout. And of course, with my remarks as to the background claim in mind, we say that this is particularly relevant because if there was, as is alleged, a secret scheme between the claimants, then of course documents passing between the claimants themselves are going to be of critical importance. And what we see in the right-hand column is what was disclosed under request 1. There are 1, 2, 3, 4, 5 emails. Pausing there, those are obviously by their descriptions, they're all described as emails passing from Paul to Donna or Donna to Paul. My lord, Donna is the defendant, and so those documents were entirely unresponsive to the request, and clearly not, in any event, the kind of document which was sought to be disclosed under this request, because of course documents between the defendant and the claimants were already in her possession, custody and control. So those were not responsive. And finally, in that column, there is the paragraph saying WhatsApp conversations between Paul and Donna, mentioning about all potential buyers, Mayfair Capital, GFH and others. Now again, WhatsApp conversations between Paul and Donna were not responsive because Donna's the defendant. We asked for all correspondence between the claimants. So at the 15th of September, nothing was actually disclosed that was relevant under request 1, despite the fact that that is in our submission the critical request, where if there is documentation, one would expect to see it. Now, I want to pause on the point of WhatsApps because that position has developed significantly, we say, since the 15th of September. What was disclosed at that date, and I can take your lordship to it, but I don't think you particularly need to see it. But what was disclosed at that date was a PDF document, which was headed Anoop, that's the first claimant, WhatsApp messages, all I could find on phone. And what that document appeared to be was a PDF where the first claimant had copied and pasted WhatsApp messages across to a single document. And as was said in the description, all I can find on phone. There was no particular comfort that that disclosure of the WhatsApp messages was complete. So one of the complaints in the correspondence was to say to the claimants, look, this isn't a native export of the WhatsApp chat. It's obviously relatively simple these days to export a WhatsApp chat. And these documents should be A, disclosed in their native form, but B, should be complete. And I pause there to say that there was no disclosure of WhatsApp messages from the second claimant. It appears to be said by the claimants still today that that wasn't necessary because either one or the other of the claimants could disclose their WhatsApp messages in reliance, I think, on REC 28.15, which says that a party doesn't need to disclose a document if another party is disclosing that document. But we say that that only works if the documents are carbon copies of each other. And of course, we have no guarantee that that was the case here. The first claimant had copied and pasted messages. We don't know if it's the complete chat, or rather we didn't know if it was the complete chat. It now transpires it was nothing like the complete set of WhatsApp messages. And in any event, what's sent by one person and received on another person's phone, we say isn't a copy. It is possible for people in WhatsApp chats to delete messages on their own devices, but for those to remain on somebody else's device. So we say that as at the 15th of September, the second claimant really ought to have disclosed his messages as well. The explanation that's given is that the claimants agreed between themselves that one of them could just disclose their WhatsApp messages. And then we say that's obviously not good enough. And the second claimant signed document production statement saying that his disclosure was complete without explaining that he had withheld his WhatsApp messages according to some sort of agreement with the first claimant that he didn't need to disclose them. So we say that was a clear breach of the order. But in any event, the WhatsApp chat wasn't complete. If we fast forward to the 1st of November, my lord, we then have further disclosure following, I think, 2 rounds of correspondence. There's further disclosure of more WhatsApp messages, and those are more extensive. There's about a year's more date range included in those WhatsApp messages, but they're still in PDF rather than native form. And then it's only in response to the application on the 8th of December, following the directions hearing, that we get a full exported copy of the WhatsApp chat. And the reason I emphasize that is because it becomes clear from some of the WhatsApp messages that actually there are far more extensive documents potentially out there which have just not been grappled with by the claimants at all. And I think at that point it's useful if I pause and if I could take you to my skeleton argument, which is tab 20.
Yes, I have it in. Whereabouts am I going?
So paragraph 22, my lord, which is at the top of page 412 in the bundle.
Yeah.
This is the summary of what's disclosed on the 1st of November. What I'm interested in is the sub-paragraphs, because what's become clear from the defendant's work in investigating the WhatsApp messages is that there are a number, and these are simply 4 examples, but there are a number of messages where the claimants, together with Mr. Atkinson and Mr. Ashford, who are relevant to requests 2 and 3, where those parties discuss sending, forwarding emails and documents to their private email accounts. And there are a number of references in this chat. You see there at 22A, gents have forwarded email from Panmure, pausing there. Panmure was one of the prospective purchasers of the entertainer business. Have forwarded email from Panmure to your private email accounts. Regards, Steve. Gents see private emails. Macquarie Capital, that's another potential purchaser. Meeting 9 o'clock next Thursday in London. There's a reference at paragraph 22C to a presentation in the WhatsApp chat. And again, indeed, hi Stephen, did you get my note? And so when we had the more extensive version of the WhatsApp chat, it became clear to what extent the claimants and these individuals were using private emails to communicate between themselves. And of course, your lordship's seen, because we were on the page a moment ago, none of those documents had been disclosed under request 1, none whatsoever. I'll be corrected by my own friend, but I don't think there was a single email emanating from a private email account that was disclosed by the claimants in their September disclosure. And so this was obviously a cause for concern because it appears from these messages, not only are they corresponding in their private emails, but those are messages that are very relevant, we say, to the allegations that are made in the defence and counterclaim, in that they are clearly discussing meetings and documents from potential purchasers. And it's right to say, my lord, that the explanations that have been provided by the claimants in their affidavits, we say, are wholly inadequate. But I want to take you to perhaps one further message, which is, my lord, I apologise, I've just lost the reference. In the 4th witness statement of Miss Burt, it's perhaps easiest to go here where it's extracted. Tab 18 of the bundle.
Yes, what paragraph?
And it's paragraph 22B, my lord, on page 325. And the set out there is a WhatsApp message from Mr. Atkinson to the claimants and Mr. Ashford. Gents, it was a good day today. Keep the faith. I believe we will get to where we want to be. One crucial point, and this is our emphasis. What we need now is absolutely tight behaviour between the 4 of us, as even this and the other side tried to get the guys to deal direct with them, i.e. without my involvement, let alone the management team. I've spoken briefly with David, but didn't get a chance with Paul, that's the second claimant, or Anoop, that's the first claimant, before I left the office. We should not use and cannot have back channels to the shareholder direct. And the shareholder is, of course, the defendant, Donna. They will send everything to me, or at the very least CC me. The moment the shareholders believe that they can deal direct with GFH, that is the ultimate purchaser, my lord, of the entertainer business, is the moment our ability to shape the outcome is gone. And finally, let's meet soonest Sunday AM, preferably away from the office. And we say that this message is particularly relevant because it directly rebuts the explanations which are given by the claimants as to why they haven't disclosed a single one of these documents. It's worth looking at what those explanations are. broadly, what's said by the claimants is that there are no relevant documents passing between either them under request 1 or between them and Stephen Atkinson and David Ashford, that's requests 2 and 3, for 2 reasons broadly. The first is that they say because their offices were next to each other within the Entertainer, all or substantially all of their discussions were about the management buyout were oral. And so there were no documents or very few documents created, and such documents as have been created have already been disclosed. And the second reason that they give is that they say that all relevant documents must have been contained on the Entertainer server, and that since they've left their employment with the Entertainer and in compliance, they say, with their confidentiality obligations, they didn't retain documents that were contained on the Entertainer server, and so have no relevant disclosure to give. And now we say that both of those explanations are false, and we say demonstrably false from at least some of the documents that I've just shown you. Firstly, there was extensive written correspondence between the claimants, Mr. Atkinson and David Ashford, and that's clear from the WhatsApp chat alone that was very belatedly disclosed. There are daily messages through the relevant periods and extensive chats. So it's not true to say that the discussions were entirely oral and so there were no documents to disclose. It's also not true to say that they would have discussed these matters in the office, because as your lordship sees from the message I've just shown you, Mr. Atkinson's saying, let's meet preferably away from the office. So there's evidence there that the claimants and the relevant individuals were meeting away from the office, deliberately, we say. So that explanation, we say, is not right. And then the second explanation, that documents must only have been contained on the Entertainer server, we say is also not right. Again, clearly there's the WhatsApp chat, and that's an extensive exchange of documents which wasn't contained on the Entertainer server, and obviously messages to which the defendant, the shareholder, Donna Benton, didn't have access. But we say it's also contradicted by the fact that, as your lordship has seen, there are extensive references in these documents, in these WhatsApp chats, to private emails, to documents being circulated to private email accounts. And so the assertion that all relevant documents must be contained on the Entertainer server, we say simply isn't borne out by the disclosure that they have given or belatedly given.
Sirs, can I just interrupt for a moment?
Of course, my lord.
The essence of what you're saying is that there is reason to believe that there are relevant documents in the private emails of the claimants. That's the bottom, isn't it?
That's exactly what I'm submitting, my lord. Yes. And just
hang on. The obligation is to search and disclose. I don't know that I'm terribly concerned at the stage that I want to be at of sorting out whether there has been compliance with the order, as distinct from on the unless point, with whatever excuses are being offered. Am I not interested in whether they have complied with the order by appropriately saying what searches they have conducted and what they have found?
Well, my lord, in a sense.
Addressing?
I'm sorry, my lord, my sound broke up a little bit there. Can you repeat the last comment?
I said, is that not what you should be addressing?
Well, my lord, I was about to show you what the claimants say in terms of what they have done to try and locate these documents.
Yes.
And so if one looks at paragraph 50 of the first claimant's affidavit, for example, that's at tab 12 of the bundle.
Yes.
Paragraph 50 on page V238. And what's said there is that I reiterate that I have searched my personal email following my review of the Black Cod chat, and other than correspondence produced pursuant to the document order, have not been able to locate any emails. I presume that the reference to private email accounts may have been to the entertainer.me.com email addresses. I'm unable to confirm this as I do not have access to the entertainer mail server. Now, in my submission, my lord, that does not amount to compliance with the order, because there is an inadequate explanation of what search has been conducted. That's the first point, which I'll develop. And secondly, and in any event, there's no attempt to explain, and this was ordered, it's an obligation in any event under the RDC, but it was specifically ordered by your lordship. There is no attempt to comply with paragraph 1C, which is to explain if these documents are no longer in the claimant's possession, custody or control, what has happened to them. Instead, what we have is a wholly self-serving assumption that the references to private email accounts must be, in fact, to their employment email accounts. And we say that's clearly self-serving and obviously rebutted by the documents I have shown you. That simply cannot be true. So there is no explanation as to why these documents are not in the first claimant's possession, custody and control. But as to the search that's been conducted, we say simply saying, I have searched my personal email and I haven't found anything, isn't good enough. And if I can make that good, perhaps, my lord, by if we go back to my skeleton argument, tab 20, paragraph 35. We say that the rules and the authorities are very clear that one cannot simply state I've searched and there isn't and there isn't any documents. That's not good enough. RDC 28.42, which tells one how to produce a document production statement, and then Schedule B, which is the model document production statement. They're very specific. They require the party to explain the extent of the search for document, what the relevant date ranges are, the custodians that have been searched, what devices have been searched, and how they've been searched, with reference to what key terms, and of course to explain, and this is crucial, my lord, to explain what has not been searched. And that explanation is obviously necessary, because then without that explanation as to what's been searched, we don't know if we can reliably conclude that from that search there can be no further documents. Now we say, in respect of what's been said, I'm sorry, my lord.
We've got the usual problem of delay with these video things, and so I apologise if I appear to be interrupting.
Not at all, my lord.
That Schedule B requirement doesn't really have much to do with the present exercise, because we are talking about a search of private emails accounts. So there's no point in, if we're concentrating on these, there's no point in saying I did not search the file XYZ in paper form in explaining what you searched about in your email. But your core point is that there is no explanation of what search or even what email accounts we're talking about.
Precisely, my lord.
And
we don't know.
Was done.
We don't know what
how it was done.
I do apologise, my lord. I think there's a sound lag, and I do apologise if I'm talking over you. It's not my intention. It's precisely that point, my lord. We don't know even what these personal email accounts are. And in fact, there was an attempt by the first claimant to say, well, it must be my work email address. We don't know what they are, and we don't know how they've been searched. There's a suggestion that they've been searched by reference to keywords. Now, in my submission, that's an odd way to search for documents when there's a WhatsApp chat which tells you precisely the day, date, and time when someone's messaging the first claimant or the second claimant saying, gents, I've forwarded you a document. It would be far more appropriate to search for that document by looking at the relevant date. But we just don't know if that's been done. There's no suggestion that it has been done. And it's somewhat contradicted in any event, by the assertion that, well, maybe it was all to do with my work account. So we don't know what search has been conducted. And the reason why that's important is explained by Justice Chadwick in the Talim decision, which I've set out at paragraph 36. We can go to it, and there's a copy of it in the bundle if your lordship wants to see it, but I think the relevant paragraphs are extracted here. And Justice Chadwick explained that it's not good enough to simply adopt what is the language of RDC 28.39 and say no documents have been located as a result of the search. And the reason why that's not good enough is because by the time you get to that point, you've already been ordered to make a search, and the extent of that search has been specified. And so that provides a context in which the court and the requesting party can see what has been done to find the documents. And so that enables them to take a view as to whether the fact that they haven't been located after the search is a reliable indication that they probably do not exist. And that's the key point, my lord, because we're here trying to work out, well, the claimants say they haven't found any documents. We've got extensive WhatsApp messages saying that there were all of these documents being exchanged on the private email accounts, and they cannot find any of them, apparently, after the search that they've conducted. Is that a reliable indication that they probably do not exist? And we say no. We don't know what search they've conducted. But the fact that not a single document has been located suggests very probably that that search was not good enough. And so we're entitled at the very least, my lord, to an explanation of what search has been done. But we would go further than that and suggest that it's open to your lordship to order that that search be carried out properly, because there's clear evidence that these documents did exist. I've shown your lordship 5 references, but I could show your lordship others. There's clear evidence that there's extensive correspondence using private email accounts. Nothing has been disclosed from those email accounts. We don't even know what they are. We don't even know what addresses they are. And adopting Justice Chadwick's language, we say that that search is not a reliable indication at all that those documents don't exist. In fact, what's far more likely is that the search was deficient. So that's the point about the search, my lord. We say that what's been done simply isn't good enough, and that we're not confident at all that these documents couldn't be found.
Hang on. Let me say for Mr. Krishna's benefit that a similar point to the point you take from Talim can be seen in the terms of the order which was actually made, which required that a reasonable search be undertaken. Unless it is explained what was done by way of search, it is impossible to judge whether or not it was a reasonable search. That's another way of putting your point.
Precisely so, my lord. And I come back to the point that the reason I emphasise this is, and because as I explained to you at the outset of my submissions, the nature of the allegations are that the claimants were having secret discussions between themselves. Those are documents, obviously, that the defendant doesn't have access to. And the fact that not a single document has been disclosed as a result of these searches for private email accounts, we say is at the very least should be regarded with suspicion.
Well, now that's the email accounts. What else in relation to categories 1 and 3, which your skeleton dealt with together? There is the question of the annexes or attachments to emails, which perhaps you might help me to understand.
My lord, yes. Just by way of final comment on what we've just been discussing, I would remind your lordship that, of course, paragraph 1C of the order required the claimants to say, if they don't have the documents in their possession, custody or control, what has happened to them.
Let's move on.
Thank you, my lord. So as the attachments to emails is a point that we struggle to understand why this is still an issue. What happened on the 15th of September was that there were a number of emails disclosed, not in native form, and so without their attachments. And the attachments appeared from their descriptions that they would be at least potentially relevant documents under these requests, because they were attached to emails between the claimants and Mr. Atkinson or Mr. Ashford, and so responsive to requests 2 and 3. And there were 13 such attachments, and these were set out and identified fully in correspondence. So if your lordship looks briefly at tab 11, page 133.
Yeah.
This is the letter from Curtis to the claimant's former practitioners of the 7th of October. And here it's set out very clearly what those attachments are, what the documents are that they're attached to. And they're all fully particularised. There are 11 of them. What then happens is that between the 18th and the 22nd of October, Bin Eid, the claimant's former counsel, send a series of emails, and they disclose 6 of the 13 attachments that have been referred to in this letter, but the remaining 7 are not disclosed, and we're just not clear why they haven't been disclosed. The claimants say that they don't understand why there's a reference to 13. They've disclosed 6. Well,
stop. Watch me. When I put up a hand, it means stop, right?
My lord, I'm so sorry. My video is freezing. I think it's yes. I can hear you now. I apologise.
That's all right. When I said that I asked for your help in understanding it, my understanding was that your side says that there were 13 attachments which were referred to and prima facie should have been disclosed. 6 had been late disclosed, but 7 were outstanding, and I was uncertain of Mr. Krishna's position. It seemed to be, it was not clear to me whether he said that the other 7 had been disclosed or not. I was wondering if you could help me on just what the position is.
My understanding, my lord, is that, and I'll be corrected, of course, by Mr. Krishna, but my understanding is that they haven't disclosed the other 7, and they don't think there were 7 further attachments to disclose. We're not entirely clear as to why, but as far as we understand the position, they accept that only 6 attachments have been disclosed.
Well, are you saying, do your complaints include that the other 7 should be disclosed, or at least an explanation should be given as to why they are not disclosed?
My lord, that is my position. Prima facie, we say they are disclosable under request 2 and 3 because they are documents attached to emails, which are communications between the claimants and the relevant individuals. But even if they are not, and if we're wrong about that, then the claimants have to tell us why we're wrong about that.
Right. Now you say request 2, your outline, your skeleton seemed to refer to requests 1 and 3 and didn't really say anything about 2. 2 was Mr. Ashford, wasn't it? Yeah, that's Mr. Ashford. Is that part of your complaint or not?
It is, my lord. Mr. Ashford's name, you'll have seen, is referred to in the WhatsApp chat. So we say the WhatsApp chat is evidence that there clearly was documentation passing between the claimants and Mr. Ashford. We haven't identified specific examples of documents that are referred to in the chat as between the claimants and Mr. Ashford rather than the claimants and Mr. Atkinson. But what I've addressed your lordship on in terms of the adequacy of the search and the failure to explain why there are no further documents, those points are equally relied on, my lord, in relation to request 2 as with requests 1 and 3.
Right, thank you. Well then, so we've dealt with 2 things in relation to request 1, 2 and 3. First of all, the emails, the personal emails. Secondly, the missing attachments. Is there anything else?
There is, my lord, yes. With regards to request 3, for communications between the claimants and Mr. Atkinson. And this also goes potentially to requests 7 and 10. I say potentially, and I'll explain why. There was reference in correspondence between Mr. Atkinson's legal counsel, Stevenson Harwood LLP, and Curtis, those instructing me. There was correspondence in which Stevenson Harwood confirmed in a letter dated the 13th of August 2018 that there were documents between the claimants and Mr. Atkinson. It's the relevant bits of that letter are extracted in a letter from Curtis at tab 11, page 131. In fact, Your Lordship might simply be able to scroll down from what we were previously looking at. Page 131, this is a letter from Curtis dated the 7th of October to the claimants, paragraph 30.
Just give me a minute, please. I seem to have frozen.
I'm sorry, my lord, can you repeat that?
My iPad has frozen. Give me a moment.
Of course.
One could get to hate technology. What I'm looking at is at paragraph 30 of a letter from Curtis.
Precisely, my lord.
Okay.
This
Yes.
is an extract from a letter from Stevenson Harwood, which was Mr. Atkinson's counsel, and it referring to email and WhatsApp correspondence between Mr. Atkinson and Mr. Hennessy on a particular point. And then you can see quoted there, in particular, there are some WhatsApp messages. And there was a further letter referred to in paragraph 31, making substantive references to further WhatsApp exchanges. And over the page on paragraph 32, we say that this was an issue that had been canvassed earlier, and the second claimant's position was that he had certain WhatsApp communications. We don't know precisely which, whether they were the same ones, but he had certain WhatsApp communications in his possession, custody, and control. He didn't deny that those messages existed, but he said that they're personal and would need an indemnity prior to sharing them. Now, as far as the WhatsApp messages are concerned, we don't, and I'll be corrected, but I don't think we see those WhatsApp messages anywhere in the chat that's been disclosed. So those appear to be additional to what's been disclosed in these proceedings. But there's also references to emails by Stevenson Harwood and rather extensive correspondence. And this was pointed out to the claimants on the 7th of October. And it was fairly asked. We say, well, clearly these documents were in existence. The second claimant has accepted that at least some of them were in his possession, custody, and control. You have not explained why you have not disclosed them. Are they no longer in your possession, custody, and control? And if so, why not? There's never been a response to this, my lord, in any of the subsequent correspondence. And as far as we can see, the second claimant doesn't deal with this at all. So despite the fact that it's been confirmed that these documents exist by Stevenson Harwood, and they don't appear to have been disclosed, we simply don't know what's happened to them and why it is that the second claimant hasn't disclosed them. So that's a further ground, we say, to suspect that there are more documents which haven't been disclosed. The final point in relation to requests 1 is that not a single WhatsApp message has been disclosed as between the claimants themselves, just the claimants themselves. It's said by the claimants that they have searched their exchanges as between them, and that there's nothing relevant to this dispute, that it's all either personal or operational to the business, and there's absolutely nothing relating to the buyout. And we suggest that in the context of what's been disclosed in the WhatsApp chat, that is inherently implausible. In particular, where both claimants say that they remain close personal friends, we say it's surprising, to say the least, that there is not a single message been disclosed as between the claimants themselves.
In that case, I think that at least one of the claimants, I can't remember which, says that he has searched WhatsApp message using keywords provided by the defendant. So he had, to that extent, there is an explanation of the search.
That's right, my lord. But what's not said in relation to that is whether there were any messages relating to the buyout, and if so, why they're no longer in their possession, custody, and control. We suggest that it's implausible that there wouldn't be any, but there it is.
Well, so the question here then comes down to one of messages that were in their possession, custody, or control, but are no longer.
Yes, my lord, that's right.
I understand that. Thank you. Right. That's a little tricky in that one has to go by what the disclosure says about what was in the disclosur's possession or control. If the disclosure says, I cannot remember that there was anything else that I had but no longer have, what more can one do about that? I appreciate that your point is that not even that is said, but let's assume that is said.
I accept that, my lord, and what I would rely on is that it is also said in relation to request 1 that other than the emails that were disclosed, they don't remember there being any other documents under those requests either. And that, as I've shown your lordship, is we say comprehensively rebutted by the chat that has been disclosed, which suddenly refers to a whole host of other documents which were created. And so we say at the very least it's unreliable what's being said about memory.
That is an entirely different point. If they say we searched and found nothing, they're looking at what there is, what they've got. Whereas on the point of what they used to have but no longer have, there is really no alternative, is there, in the discovery regime to accepting, at least prima facie, what the disclosure says.
Well, my lord, I accept that the claimants say that they have searched the keywords provided by the defendant. Obviously, what's not said is where they've searched and what date range was applied and whether they've checked backups. For example, the first claimant says that he changed his phone in mid-2018, and that was the reason why WhatsApps prior to that date were not disclosed. And so it's not necessarily accepted that the search that they have done was the full search and the reasonable search that was ordered. But if your lordship accepts that it was a reasonable search, then I accept that one simply has to take the universe in which we find ourselves. But there's still no explanation as to why those documents are not in their possession.
That is not the point that I was making, but let us move on. Okay, so those are your complaints about categories 1, 2, and 3.
My lord, yes. So looking at requests 4 and 5.
Well, let's stop there. It would seem to me to be useful if I now ask Mr. Krishna to address me on categories 1, 2, and 3, and then we can move on later on to the other categories.
Of course, my lord.
Is that convenient? Does that cause a problem to either of you?
Not at all.
No, it doesn't, Your Honor. Although I would have preferred to make my submissions in relation to all categories to start with before getting into individual categories.
Well,
But
in that case, let us not take that course if you need to give it more general explanation. But might I say, Mr. Krishna, from those few remarks, I'm finding it very difficult to hear. You're coming through with a lot of echoing and a lot of difficulty in my understanding what you're saying.
is this better, Is this better, Your Honor?
That's a bit better, yes. So so we can test it out.
All right, Your Honor, it may be better if I may suggest for Ms. Hurst to proceed with her submissions because I need to preface my submissions on individual categories with submissions relating to the search as a whole.
All right. Thank you. That's fine. That comes through well. So if we can try and do that in due course. So we'll return this to Ms. Hurst and ask you to move on to other categories. Yes, Ms. Hurst.
Thank you, my lord. So requests 4 and 5, if I can take those, they were requests for documents between the claimants and Mr. Ashford and Mr. Atkinson respectively, with other potential third-party investors. And the position that's taken there is that all the documents relating to those requests have already been disclosed and that they have no, that they haven't been able to identify any further documents. Now, again, I won't repeat myself, but again, here, there is no adequate explanation of the searches that have been performed. It's not said, where they've looked, how they've looked, date ranges, keyword searches, and so on. And so everything I've said in relation to that applies.
In your skeleton, you say you do not ask for a relief in relation to request 4, 5, 8, and 10. You reserve the right to comment. So they are not matters with which I'm concerned.
No, my lord, there was just one document that I perhaps should have shown you under, which we say is relevant to request 1. Which was a reference by the apologies, my lord, I've lost the reference of what I was going to take you to. I'm sorry, my lord, my bundle has frozen on screen. I do apologise. I'm just waiting for that to reload. Right, my lord, I'm sorry about that. I'm back online. I do apologise for the delay. Your lordship's right. We don't seek specific relief in relation to those requests. There are further examples of references in the WhatsApp chat where we suspect that there would be documents that are responsive to those heads. But I won't repeat the general submissions that I've made in relation to the documents between the claimants and those individuals. We suspect there would be further documents, but preserving our right to invite the court to draw adverse inferences, we don't specifically seek relief in relation to them. I can take the rest of the requests, I hope, my lord, fairly swiftly. Again, in relation to request 6, the response to this request was that they weren't involved in the incorporation of the entertainer, and so the request for those documents.
Again, you do not seek relief in relation to 6, according to your skeleton.
That's correct, my lord, yes.
7, 9, and 11.
So request 7 we say is potentially, there are the documents that I showed you in relation to Stevenson Harwood, potentially some of those documents would fall within this request. Because again, that's a reference to, that was correspondence between the claimants and Mr. Atkinson. Request 7 is more specific, but at least potentially some of the correspondence there may be responsive under request 7. Now we just don't know because the claimants haven't provided an explanation as to why those documents are not responsive to request 7, if that is the case. And again, they've not explained what has happened to them if they're no longer in their possession, custody and control, and they've not explained the search. So we say that what I've already submitted in relation to the Stevenson Harwood documents, if I can call them that, that may well apply here, and it's incumbent on the claimants to explain why those documents are not responsive, given that there's grounds to believe that there may be documents there. Request 9 was a request relating to documents evidencing the claimants using the entertainer bank account to pay expenses. I can take this very briefly. In the 7th of October letter at page tab 11, page 132.
Yeah.
There, from a review of the documents disclosed, Curtis set out extracts of documents which appeared to suggest that the claimants were paying expenses. This is paragraph 37 of the letter at the bottom of the page, my lord, if you have that.
Yes.
And one can see from the WhatsApp messages reference to, we'll pay your expenses from our accounts over the weekend. Can you resend your typographical error, I believe, but can you resend your IBAN as it's coming up as invalid? Not able to make expenses payment as OTP facility for both banks is down. We'll pay first thing Sunday. So we say that although the claimants have said they've not been able to locate any documents in their possession, custody or control responsive to that request. Firstly, they didn't specifically disclose these messages. They weren't referred to in the response to this request. But in any event, the fact that these messages have been disclosed rather suggests that there would be other documents. And the denial that the claimants ever paid any expenses is obviously, we say, likely rebutted by these documents. So that gives grounds to believe that there are further documents that have not been disclosed. And again, my lord, I pray in aid the general submissions about the failure to explain the search and the failure to explain why certain documents which appear to have been in their possession, custody and control are no longer in their custody and control. So that's request 9.
Yep.
Apologise, my lord, I've got a slow loading bundle again. Request 10, we've dealt with, my lord. And finally, request 11, again, is the general complaint. We say that there's just a blanket denial that any such documents have been found as a result of the search. But again, there's been no attempt to explain the search and no attempt to explain why documents that were in their possession, custody and control are no longer in their possession, custody and control. And so, my lord, if I could sort of summarise, I've not emphasised to your lordship, obviously, the difference between where we are now and where we were. But we do say that much of the information that's been provided was only in response to the application. And even then, after unsuccessfully trying to persuade the registrar that there was no further steps that needed to be taken, it was only after that that we had the disclosure of the WhatsApp chat in native form. And as you can see, my lord, the WhatsApp chat really does ground a lot of the suspicion that we have that there are further documents that have not been addressed. And we say that although the claimants pray in aid their 14th of December affidavits, We say that the explanations that have been given in there don't stack up. They're contradicted by the plain documents that I've shown you, and that these points are not new points. They've been raised in correspondence since the 7th of October, and the claimants simply haven't sought to grapple with them. And that in and of itself, we say, despite many attempts to ask why these documents are missing, the fact that it still hasn't been explained, we say, gives grounds for suspicion. And so it's my position that the order was clearly not complied with at the 15th of September. But in any event, even where we stand today, there remain gaps, and we say fairly obvious gaps. The most significant of which is, of course, the private emails and the failure to disclose any documents under request 1. My Lord, obviously I can address you on remedy in due course, but that might be a convenient moment for you to hear from Mr. Krishna about the requests.
Yes, it is. In line with what I desired, that is, to see where we really stood at present. Mr. Krishna.
Your Honor, before I begin, and purely on health grounds, may I request a 2-minute break, if it's convenient to you? I hate to interrupt the proceedings, but I have a minor health issue.
Yes, certainly. We'll resume in, would 2 minutes enough or 5 minutes better?
Yeah, 2 minutes should be.
2 minutes, all right. I'll leave my, I intend to leave my screen on and I will just sit here. Do you want to leave your screen?
Yeah, I will leave and I'll be right back. Thank you.
Yes, all right.
Your Honor, I do apologize. Can you hear me all right?
Yes, I can. Thank you. Yes. Ms. Hurst, are you still with us?
My lord, yes, apologies. I'm getting a message that my internet connection is unstable, so I've turned my video off so that I can still hear you. I hope that's acceptable while Mr. Krishna makes his submissions.
No problem at all. Thank you, Mr. Krishna.
Thank you, Your Honor, and thank my learned friend for her submissions. If Your Honor still has the defendant's skeleton argument in front of you, may I take you to a couple of points within that document? It would help me preface my submissions if I could do that. If Your Honor could look at paragraph 3, which is at V404, 405, you will see the assertion that the claimants have failed to comply with the document production order for a number of reasons. You'll see a list there, A, B, C, D, correspondence, more correspondence, directions hearing, affidavits. What it does not mention at all is the document production statements themselves. It's only in paragraph 16 that the skeleton even mentions the document production statements and asserts that they're defective. In paragraph 4, it's asserted that the affidavits are defective. I'll pick this up in my submissions shortly. I'll also deal with the defendant's pleaded case and the procedural history in my submissions. But may I now take Your Honor to paragraph 28 of the defendant's skeleton, which is at V413.
Yes.
I appreciate that Your Honor said, you're not dealing with the unless order just yet, but it's asserted that the registrar directed the defendant to seek an unless order. Your Honor, that is an inappropriate statement to impute to the registrar. To be fair to my learned friend, she was not at the directions hearing. I was, so it's my duty to the court to help correct this. Giving a party leave to amend is not the same as directing the party to seek an unless order. I'm not drawing this to Your Honor's attention to curry favor with you or to make some sort of emotional appeal. In fact, I disagree with a lot of what the registrar did say during the directions hearing. But this statement that the registrar directed her to make this application is important for you to note because it's part of a pattern of not taking responsibility and mischaracterizing who is responsible for what on the part of the defendant. I will take Your Honor through this pattern in my submissions. But before we get there, one further point on the defendant's skeleton, if I may. Paragraph 61 of the skeleton at V422. Here it's said that the defendant no longer seeks an order for the claimants to search and produce.
I'm
so
sorry.
why are we here?
Sorry, I missed the reference. Paragraph which again?
61.
61, thank you. I misheard.
It's at V422 of the bundle.
I have
So
it here.
Here it said that the defendant no longer seeks an order for the claimant to search and produce. So why are we here?
No, it doesn't say that. It says where in the interest of proportionality the defendant no longer seeks it. That is a reference to the earlier statements in relation to categories 4, 5, 8, and 10, and 6, where they say that in the interest of proportionality they do not. We are here because there's a dispute.
Yeah. Thank you, Your Honor. I will not press that point any further. So, Your Honor, to take you through my submissions, if Your Honor can kindly turn to the claimant's skeleton argument and have it at hand, that would assist me in this exercise. It's at V454 of the bundle. As Your Honor will have seen, the claimant's opposition to this application, Your Honor, is twofold. The first aspect we say are the fundamental threshold issues of fairness, necessity, and proportionality. The second aspect is the substantive procedural rules in Part 28. We then go on to deal with the cost issue. On the first aspect, Your Honor, the starting point is the defendant's pleaded case, her conspiracy theory. And I don't mean this in a disparaging way. She asserts a secret plot, which is the dictionary meaning of the word conspiracy. So she comes to court with this conspiracy theory and says, I have no documents in my possession, custody, or control, and I believe the claimants have these documents in their possession, custody, and control. She says her ability to provide witness evidence is impeded unless the claimants produce the documents. The rules of the DIFC codes, the RDC, state that a party is required to produce documents on which she relies and permit that party to request documents that are not in her possession, custody, and control. This is recognized in Justice Sir John Chadwick's judgment in Talim and National Bonds, which Your Honor has in the authorities bundle, and my learned friend took you through a couple of paragraphs within that. This is also recognized in Your Honor's own judgment in Orient Insurance and Hazel Middle East, which is also in your authorities bundle. I'll give you the bundle references now or later as you wish.
Your point being what?
I will get to that in a momentarily, Your Honor. So when the defendant makes this affirmation that she does not have the documents in her possession, custody, or control, the claimants and the court were entitled to take that at face value. But when it turns out that this affirmation is negated by the documents that she has produced, the documents on which she relies, the question that arises is, should the court continue to assist the defendant? How is it fair to the claimants for the court to proceed on the basis of a discredited affirmation? It could be a...
Krishna, can I perhaps try and shortcut this? An order was made. The question is whether that order should be complied with.
Yes, Your Honor. Yes, Your Honor. And our position is it has been complied with.
That is the issue before me. There is no issue about whether the order should have been made. It was made.
It was, yes. I accept that. I accept that. And the point I'm making here relates to our compliance with the order, as I will show you in just a second. So we accept that the order was made, and we are not suggesting for 1 second that the order should not have been made. The order was made, and the order was complied with. Now, in compliance with the order, my learned friend took you to paragraph 1C of your order, where the claimants were required to identify documents that were in their possession, custody, or control, and to explain what happened to them. And that's what this relates to, where the claimants say, we've done the defendant's job for her in terms of arranging her documents and in chronological order and reviewing them. And we have realized that the documents that she has produced are responsive to all 11 categories in her request to produce.
Are you suggesting that the defendant has produced correspondence between the claimants relating to the proposed MOB, that is, between the claimants?
Yes, Your Honor. The documents that are in folder 4 of the defendant's standard production of documents appear to be responsive to all 11 categories of documents. Now, I accept that I could be wrong about 1 or 2 individual categories, but for the most part, as the as the claimants say in their affidavits, these appear to be responsive to all 11 categories of documents.
I don't understand what you mean by being responsive to a category. Emails, let us assume, between the two claimants concerning the MOB are in the normal order of things, not within the possession or control of the defendant.
Yes, Your Honor. And hang
on. Even if somehow one or two came into their possession, they do not know whether they have everything. They have no way of knowing. That is the point of the discovery. Is it not?
I will develop this point further, my lord. The second claimant has given affidavit evidence saying these are the documents that I have given to the defendant back in 2018. And now she has now produced these documents as part of her disclosure. And the rules of this court, as recognized in Talim, say that once documents are produced by one party, other parties are not required to produce them. And there's a practice note issued by the Chief Justice that says if you're producing documents, whether you're filing or serving them, you have to provide an index describing each document. That was not done in this case. So it was only very lately that the claimants realized that these 200 documents that are in the defendant's standard production of documents are actually the documents that she says she doesn't have.
Why does this mean that you do not have to disclose documents in answer to, say, category 1?
It does not. It does not. What we are saying is...
You're telling me about
it. We do not, for a moment, say that we do not have to comply with the order. What we are saying is, in compliance with the order, we have identified these documents as those that were previously in our possession, custody, and control and are no longer so. Now, there's a small distinction to be drawn between what Justice Chadwick says in Talim and what you say in Orient, and in the document production order in this case, where you say the party from whom the disclosure is requested has an ability to object on the basis of RDC 2828. And Justice Chadwick says, there's no inconsistency here. He just begins at an earlier stage and says, when a request is made, the party can say, I don't have to produce these documents because they're already in your possession. And so, or you have already produced them. And so they're excluded from production. Now that ability was taken away because there was no index. There was no way we could have figured out sooner that these documents are actually responsive to the request to produce. Now, despite that, and these are 90% of the documents, what we're talking about in terms of what the search and produce, that has only led to the discovery of another 10% of the documents. So in relation to that, the claimants say there was no secret plot. The documents on which you have produced, on which you rely, show that you knew about the management buyout at the time. The financial information that we shared with third parties was in the context of customary due diligence in M&A transactions. To this, the defendant's reply evidence is that she can deal with this in her witness evidence. So if that is the case, what's the necessity for a further order? Then, Your Honor, we submit that the application does not satisfy these fundamental threshold grounds of fairness, necessity, and proportionality. But these are inherent in the RDC.
So let me stop you again. That is why I reminded you that the order had been made.
Yes.
Only question is whether it has been complied with.
Yes, and I'm coming to that just now. This is the second aspect of our opposition to the application, which is we have complied with the order, and there's no strong and convincing evidence before you to prove that the order has not been complied. Now, the question is, how does a party demonstrate compliance with the document production order? The authorities are clear. Both Taaleem and Orient Insurance stand for the proposition that compliance with the document production order is to be demonstrated through a document production statement. And here again, with the greatest respect, Justice Chadwick goes a bit further in Taaleem than Your Honor does in Orient. If I may take Your Honor to paragraphs 31 to 40 of Taaleem, you have Taaleem at V564 of your bundle. And
Sorry. Paragraphs again, please.
V564, paragraph 31.
Yes.
So 31 to 40 are the most relevant paragraphs of this judgment that deals with this situation that we're facing today. So it starts, as I said earlier, with the statement that a party is required to produce documents on which he relies, and not except for documents that have already been submitted by another party. That's in the middle of that paragraph. And if you scroll over to the next page, Your Honor, the paragraph 36, by the time a party is in a position to state in a disclosure statement, which is now called a document production statement under the 2014 RDC, by the time a party is in a position to state, I have not been able to locate documents, he is doing so in the context of a search which he has been ordered to make and the extent of which has been specified. And this process is reinforced in the case of electronic documents, because there's a strong reasonableness factor there. And in paragraph 37, Justice Chadwick says, a party has to tell the court what has been done in carrying out the search. And going further along that train of thought, in paragraph 38, he says, it would be sufficient if the answer, no documents have been located, were made following a disclosure order. In that case, it would be sufficient to state, I have made the search that I was directed to make, and the document has not been located. That is what the rules and the disclosure statement require. And then he goes in on the facts of that case to say, okay, when you say no documents have been located, have you done the search? And Mr. Knowles, QC, says, yes, we have. We will provide the clarification. So at paragraph 40, Justice Chadwick says, on the basis that that statement is made and that clarification is provided, I do not find it necessary to make a search and production order in relation to the documents in this case. Now, the same principle applies. I mean, at that point, he's talking about prior to the making of a disclosure order. But the same principle applies once a document production order has been made and document production statements have been made. So once the statement is made and the clarification is given, there is no need for a further order. Of course, I accept that we have to show you what exactly we've done, and I'll come to that in a second. But if I may just take you through to the remaining paragraphs on page 566, this should, these are relevant as well. So paragraph 41 on page 566. Should the second defendant now be required to make a better or more comprehensive search? Is there a need for a better or more comprehensive search? Now, the answer to that depends on what is said in the document production statements and the affidavits. There's no need to look at them separately because now, they need to be seen together. Otherwise, it would be an artificial distinction. In paragraph 42, he finds that in that case, documents have been searched. Both those individuals have searched on the same basis as the claimants have in this case. And accordingly, in paragraph 45, in relation to those two parties or those two individuals, Justice Chadwick says, I don't find it necessary to make any further order. So, again, Your Honor, as I said before, we don't have to revisit the document production order. We accept that it has been made. Our position is we have complied. What we need to do is apply the Talim logic to the document production statements and affidavits here. You see, are they compliant? Do they state that the required search has been made? Do they give details of the search? Is it stated that the documents located as a result of the search have been produced? Is it stated that no further documents have been located following a reasonable search? We submit, Your Honor, that once you're satisfied with that the relevant statements have been made and the relevant clarifications to the extent necessary have been given, you should follow the Talim principle and make no further order. On that note, Your Honor, if I may now proceed to show to you that the document production statements and affidavits are in fact compliant with, or in fact verify compliance with the document production order.
Yep.
The burden of proving that they are not compliant lies with the defendant. And discharging that burden on the balance of probabilities requires strong and convincing evidence. That's the rule in this in the DIFC courts, as stated by Justice Field and Justice Sir Richard Field in Graciela and Giacobbe. In Graciela, Justice Field found after a trial and cross-examination of lay and expert witnesses that strong and convincing evidence did exist in that case. In this application, Your Honor, you're being asked to dispense with a trial and make these findings on an interim application. You're being asked to disregard sworn affidavits without cross-examination. You're being asked to accept witness evidence, the same witness evidence that says the registrar made me seek this order, from a defendant who says, I don't have these documents. So if Your Honor relies on that evidence as the basis of your inquiry, we submit you would be unfairly forced into the position of brokering a negotiation between the parties rather than make an effective determination of the disclosure issues. And that's the principle that's stated in by the High Court in Fine Care.
Well, can you help me? What part of Graciela are you referring to, please?
I will in just a second. So it's in my skeleton at paragraph 18, which is at B463. Paragraphs 3 and 4 of Graciela, which is at V501 of the bundle, and the specific page number is 503.
So this is the usual principle that the more serious the allegation, the higher the civil standard of proof. Is that what you're referring to?
Yes, it is. And
why does that apply at all to a situation like this?
Because there is an allegation before you that a signed document production statement and a sworn affidavit should not be believed.
No, there's not. The allegation is that the statement does not say what it needs to say because it does not explain what was done.
In either case, we reach the same place. Even that allegation is a serious one.
It is not a serious one. It is one which, in the past, in this case, seems to have been due to the inadequacy of the legal advisors.
I accept that. I won't press that point any further because, in any case, I'm in a position to prove that we have complied. So I don't need to spend any more time of Your Honor's time on this.
Okay.
Your Honor, if I may take you to pages 19 to 21 of my skeleton, which is at 472 to 474.
Paragraphs 19 to 21, did you say, or pages?
Paragraphs. Sorry, pages 19 to 21.
Okay. Give me paragraphs, please, because I have a hard copy.
All right, paragraph 39. It starts at the beginning of the page.
Yes.
Now, this is where we have dealt with the defendant's objections to the document production statements and the affidavits. So the first is we have dealt with the documents that are already in the defendant's possession. We then deal with the search parameters. And as you can see, the claimants have stated on oath, they've repeated this, they've stated this in their document production statements and in their affidavits. We have searched all our private mailboxes and WhatsApp communications using the keywords provided by the defendant.
Again, and I'll stop you there. Can you refer me to where they said they had searched their private mailboxes using the keywords provided by the defendant?
Yes, Your Honor. So, firstly, in terms of the skeleton reference, that is paragraph 39B at B472. And then...
Wait a second. First of all, the first claimant affidavit, what paragraph? Where does he say that?
I will take you there just a second. So the affidavit references are V228. I will take you there momentarily.
Give me a paragraph reference, please.
I will, just a second. I'm just pulling it up. So paragraph 5. Where he says, I've carried out a reasonable search as set out in my document production statement to locate the categories of documents requested by the defendant. And the document production statement itself, I will give you a reference for that in a second. Sorry, I'm just trying to find the... Yeah, so the affidavit reference to the document production statement. The document production statement is at B243, where he says, I carried out a search for electronic documents contained on or created by the following, among all my personal emails through keyword search, among all the WhatsApp communications found on my mobile phone, among all the data stored in my personal computer. I mean, all means all.
Right. Okay, now that anything else for the first claimant?
No, Your Honor. The second claimant makes the same statement. I will take you to the references. So V248, and the paragraph number, I believe, is also paragraph 5. Yes, where he says, at the outset, I state that I've carried out a reasonable search as set out in my document production statement to locate the categories of documents requested by the defendant and have produced all documents and correspondence in my possession, custody, and control. I have not withheld any document or correspondence that I'm required to produce pursuant to the order. But the defendant says that this is not a proper explanation. So if this is not a proper explanation, then what is? Which is why we say the burden is on the defendant to show what a proper explanation would be and why this is not it. If I may then move on, Your Honor, to these WhatsApp communications. The defendant mischaracterizes the timeline of the claimant's actions and the applicable duty under the RDC. The claimants say initially, prior to the document production order, they did not realize that they had to produce WhatsApp communications. But once the document production order was issued, they did produce them. They first produced the first claimant's copy, and that was found wanting. My learned friend has explained that there were issues with that. We don't contest that. We don't contest the fact that it was in a PDF with a heading, but the first claimant does say, as far as the messages themselves are concerned, I did not edit or manipulate them in any way. These are as I found them. But they say, no, that's not acceptable. So the claimants then look for the second defendant's copy of the same WhatsApp chat. And now, Your Honor, at the risk of giving evidence, a WhatsApp chat is basically a transcript containing all the participants' messages. So anyone, so the first claimant sent messages would be the second claimant's received messages, and vice versa. So it's one group, and every participant in the group, all of their messages are recorded in one place. So the first claimant then realizes that he changed phones in January 2018, so his phone only kept a record from that date. So what do? They go, okay, the second claimant produces his WhatsApp chat, the entire chat. And he explains there were technical difficulties. He explains this in his affidavit, that the images that were attached within that chat, those could not be exported. And eventually, on the 8th of December, those were also finally exported and handed over to the defendant's counsel. Now, faced with that, the defendant says both claimants have to produce their respective copies of the WhatsApp communications. Now, this is wrong. Talim specifically recognizes RDC 2815, which says a party need not produce any document that's been produced by another party. That goes for documents produced by the other side, and that goes for documents produced by a co-claimant. And in any event, the claimants have indeed produced their copies. The first defendant has what he has. They've explained the difference in dates. He doesn't have documents for the whole period because he changed phones. So here's the second claimant's copy. Now, coming to these email attachments, we say we found 6 email attachments, which we have produced. They say there are 13 email attachments, of which 7 remain missing. the email messages to which these files are allegedly attached are not exhibited in the evidence before you. So, Your Honor, the court is not in a position to make a determination that the affidavit evidence is wrong and that the claimants have failed to prove that these 7 email attachments don't exist. To do so would be to reverse the burden of proof.
Where have they said that they do not exist?
No, the claimants don't say that these do not exist. We say we have these 6 are what we have found. We do not understand your reference to these 7 supposedly missing attachments. So can you please explain? There is reference to some dates, but no way have we seen copies of these emails showing here's an attachment and you've not produced this. So we say, based on our reasonable search, we see that these 6 attachments were accidentally omitted when we complied with the document production order on the 15th of September. As soon as you told us that attachments were missing, we gave you what we had. And there's correspondence to that effect between the solicitors, which is at V148 to 157. And my learned friend took you through some of that correspondence earlier on. So, and again, this brings us back to the rule in Talim. So should the court draw an inference that there was a reasonable search and these documents were not located? Or should the court draw the inference that the search was inadequate? Now, based on the search parameters that we have shown to you, we submit that you should follow the Talim approach and find that there was indeed an adequate search. And these documents, if they do exist, have not been located following a reasonable search. There is no basis here to determine that the search was not reasonable. And the same point applies to emails referred to in the WhatsApp chat. Your Honor heard at length from a learned friend about various references within the WhatsApp chat to private email communications. The claimants say, we note these references. There are 3 or 4 references to private emails. They say in their affidavits, we have seen this, we have noted this reference, we have looked in our private mailboxes, and we have not found these emails. So we presume that Mr. Atkinson must be referring to our entertainer, our individual entertainer emails when he says private emails. Now,
just hang on a sec. Can you point me to where each one of them has said words to the effect, we have looked in our private emails and we cannot find those emails that are identified by the offender?
Yes, Your Honor. Firstly, B238, that's the bundle reference. And the paragraph reference is paragraph 50 of the first claimant's affidavit, where he says, I reiterate that I've searched my personal email following my review of the Blackcock chat. Other than the email correspondence produced pursuant to the document production order, I've not been able to locate any emails. I presume that Mr. Atkinson's references to private email accounts may have been to the second claimants and my personal email addresses, personal entertainer email addresses. I'm unable to confirm this as I do not have access to the entertainer mail server. The documents produced by the defendant appear to include all the correspondence between Mr. Atkinson and I.
Yep.
And the second claimant makes a materially identical statement at V260, and the bundle, that's a bundle reference, and the paragraph reference is paragraph 60.
Just let me check something else, please. Yes, thank you.
Thank you, Your Honor. Now, this brings me, Your Honor, to this assertion that the documents should have been provided in their native or original formats, and that they have not been provided in such formats.
I understand. I understood that is no longer an issue.
That it was said to Your Honor that that there's been some development, and that my learned friend, if I understood it correctly, was only referring to WhatsApp communications, not to the email messages. Now, so as far as email messages are concerned, that point remains alive. And on that basis, if I may make my submissions very briefly on that point.
I'm sorry, I didn't think there was any complaint about original native state in relation to emails. I thought that was only WhatsApp. Ms. Hurst, can you just help us in case we are discussing something unnecessarily?
My lord, I apologise. Yes, very briefly, we accept that as regards the second claimant's WhatsApps, they were disclosed in native form on the 8th of December, so that point falls away. The first claimant's WhatsApps have not been disclosed in native form, and so we say they ought to. There are emails that have not been disclosed in native form, and we say that they ought to. And in particular, it links to the attachments issue, my lord, because had they been disclosed in native form, we obviously would be able to access the attachments, which we can't. So it feeds into that problem. So there are now a small number of documents which we say haven't been provided in original format, and they ought to be. But that's the extent of the disagreement.
I should say that I don't see any reason why emails should be disclosed in native form, so we can move on from that.
Thank you, Your Honor. That brings me to this assertion that I've struggled to understand. It's in my learned friend skeleton. She didn't press this in today's hearing, but just very briefly. There's an assertion that the document production statements do not comply with RDC 2840. This is a weird one. I mean, RDC 2840 on its face applies to responses to applications for document production orders. It has no application to document production statements.
Yeah. Right. Well, it hasn't been relied on by Ms. Hurst, so let's move on.
Now, Your Honor, if you're not with me on any of these points, I will then have to persuade you that the remedy for non-compliance, if Your Honor would like me to address you on alleged non-compliance and the consequences of non-compliance, I will have to persuade you that the remedy for non-compliance is not an unless order.
Well, let's not go into that yet. Anything more you want to say on the question of compliance or not?
Just one further point on compliance, Your Honor. If I may draw your attention to paragraph 42 of my learned friend's skeleton argument. where she states, it's at V416, the paragraph is 42.
I have it.
My learned friend states a broad proposition regarding false document production statements. Now, I'd be happy to take Your Honor to our letter to the defendant's solicitors of 22nd November, where we asked them, are you asserting that the document production statements are false or were made without an honest belief in their truth? We received no substantive response to that question. So for them to now come before you and cast aspersions is frankly unbelievable. I mean,
Nothing to do with compliance or non-compliance, the fact of compliance or non-compliance, which is what we're addressing now. Is there anything more you want to say on that?
No, those are my submissions on compliance, Your Honor.
Right, thank you. Obviously, it's back to you then on compliance or not. Apart from anything you want to say of your own bat in response to Mr. Krishna, what I am wondering is in relation to the emails referred to in the WhatsApp messages, has there been sufficient explanation of the search when in the original document production statements, as Mr. Krishna has taken me to them, it is said, in the December affidavits, it is said with specific reference to Ms. Burt's reference to those emails, I have searched as in my document production statement, and that document production statement says I have searched according to the keywords. Is that enough of an explanation for search in relation to those documents?
Well, my lord, in my submission, not.
Right, why not?
I think there are 2 points. I'll be as brief as I can. One on the extent of what has to be explained and what my learned friend has submitted to you as regards what Talim stands for. And then the second point is how that's applied on the facts. I think my learned friend prayed in aid Justice Chadwick's remarks at paragraph 38 of Talim, where he said that if the search is specified in the order, then it's sufficient to say, I have conducted that search. And he asserts that that is effectively this case, that the order specified a search and that they've said that they've complied with it. And so they don't fall into, if you like, the paragraph that I took your lordship to, where Justice Chadwick says that you need to explain the search and you need to be able to show why document, so that the receiving party can tell whether that's a reliable indication that documents don't exist. In my submission, this is not a case where the extent of the search was specified in the order. What the order required was a reasonable search. And as your lordship commented in the course of my learned friend's submissions, firstly, who is to assess what is a reasonable search? And secondly, how are we to assess what is a reasonable search? Now, in my submission, it would be different if the order had said, look in these email accounts, in these folders, for these date ranges and applying these keyword search terms. I would accept that in that case, the order would have specified the parameters of the search. But where we're concerned with a request for a reasonable search, in my submission, what was incumbent upon the claimants was to specify what they had done with sufficient particularity that the court, whose job it is ultimately to assess what reasonable is, in my submission, that the court could assess whether a reasonable search had been conducted for those documents. So that's as regards the test. And in my submission on the facts, that's not made out. the first point I would, just to pick up for clarity for your lordship's reference, the document production statements that my learned friend took you to are the 1st of November document production statements. Those are amended document production statements. They're not the original ones that were filed on the 15th of September. And if I could go back to one of them, perhaps, and we could have it in front of us. I think it was page V243, behind tab 13. And I note, just by way of observation, and my learned friend will correct me if I'm wrong, but it appears to me at least that this document and the document by the second claimant are in materially identical terms, and they don't appear to have been drafted by the claimants individually, but by someone else. It looks like they're identical. And what is said in the second substantive paragraph is that in my earlier search I had noticed and was able to locate or identify certain documents, but I hadn't shared them earlier because they weren't the exact documents sought by the defendant. With regards to the balanced document search, I have carried out a reasonable search to locate it. However, I was not able to locate or identify the following documents, and so they're not in my possession, custody, or control. And then what's said in the third paragraph is I have again searched with more keywords. Don't know what those keywords are. We're assuming that the keywords that were applied originally were those requested by the defendant, but we don't know. I've done this in my personal emails. We don't know what those emails are, and WhatsApps, and we don't know, again, what those WhatsApp chats are. Are we searching all of the WhatsApps or only some of them? For electronic documents, it said I carried out a search for electronic documents contained on or created by the following among all my personal emails in my inbox. Well, a few points in relation to that. Are we talking about an inbox that is downloaded onto a computer where perhaps only some emails would be saved? Are we talking about a search of an inbox on a server? Has there been a search only in the inbox, or what about the sent items, the deleted items, archived chats? We don't know, because the phraseology is very generic. And it's somewhat contradicted in my submission by what's said under I did not search for, subparagraph 3, documents contained on or created by the claimant's mail files, document files. And subparagraph 2, I did not search for documents contained on the claimant's servers, for example. So although it's being said that personal emails and inbox were searched for, it's also being said that mail files were not searched. And in my submission, it's wholly unclear what the extent of the search for personal emails has been. And in my submission, there is a material difference between, for example, and hypothetically, the claimants searching in, for example, an Outlook app, searching their inbox folder only, which will not contain all of the documents necessarily dating back across the relevant period, where documents may have been archived, and an inbox will not, in my submission, will not contain sent items, or it does not appear at least that the search has been for sent items or deleted items. But it may be that that's what the claimant meant, we don't know. Without the relevant specificity as to precisely what folders have been searched, or even what email account we're talking about, whether that's the only personal email account that the claimants have, it really is impossible to assess whether this was a reasonable search. And I further press the point, my lord, that reasonableness has to be assessed by reference to what is being searched for, the evidence that there may be or is likely to be documents found as a result of that search, and the relevance and the importance of those documents to the pleaded issues. Those are points that are all made by Justice Chadwick in the Talene case. And I say it's relevant to your lordship's interpretation of this document production statement. Firstly, that there is clear evidence, we say, that there are personal emails that are relevant to this case, clear evidence that those emails did exist at some point. And secondly, that those emails are likely to be central to the allegations that are made by the defendant on the defence and the counterclaim. They are important documents, given the nature of the dispute between the parties. And what is a reasonable search for those documents may not be the same as what is a reasonable search for documents that are that relate to a more peripheral issue. And that's reflected, my lord, in the proportionate approach that we say we've taken in not pushing certain requests, where although we suspect that the documents do exist and have not been found, they are perhaps less central to the allegations made in the dispute. Not so with requests 1 and 3, we say. And so, my lord, I say in those circumstances, when it's simply said that I have searched for the personal emails without that level of specificity, your lordship cannot fairly make a determination that that has been a reasonable search, because we simply don't know. If we had more information, I may well be submitting to your lordship that it was not reasonable, for example, only to look in the inbox and not to look in the deleted items or the sent items. But I don't even have the information to make that submission to your lordship. And finally, my lord, obviously, it bears emphasis that in this document production statement, there is no statement whatsoever to the effect of, although there are documents that were in my possession, custody and control, they are no longer in my possession, custody and control, and the reason is X. That explanation isn't provided, despite that very clearly being an obligation to be complied with in the document production statement. And so I don't accept that a reasonable search has been done for these documents for those reasons. And we would submit strongly to your lordship that the claimants are not in compliance with the order on that ground. There are a few other points, my lord, which I'll take rather more briefly. I just want to clear up the point about whether we requested documents that were already in our possession, custody and control. We say obviously not. Whilst the defendant had access to documents on the entertainer server, your lordship, I think, has my submission that we don't accept that those documents are the extent of potentially relevant documents. And it was obviously legitimate for us to ask for documents passing between the claimants themselves, which by definition the defendant would not have access to. And my learned friend's submission that 90% of the relevant documents were disclosed by the defendant, I suggest, rather proves the point that there is a paucity of documents being disclosed by the claimants, where one very much would expect to see documents, and where, despite the clear references to documents having existed, nothing has been forthcoming. So I say there's no reason why your lordship should be troubled by any alleged non-compliance of the defendants in the face of the document production order or the document production process. We entirely reject those suggestions. I think the only other point, my lord, that I wanted to make clear was in relation to the attachments. The submission that's been made by my learned friend is that because we haven't put those documents in evidence, it's not possible for your lordship to make a determination. I don't accept that. It's been made very clear to the claimants in correspondence several times now, and in Ms. Burt's witness evidence, exactly what the documents are that we're looking for. And if I could perhaps ask your lordship to just look at in Ms. Burt's witness statement, the fourth witness statement, at page 322 of the bundle.
That paragraph.
That's tab 18.
Paragraph 22, is it?
Sorry, it's paragraph 12C, my lord. You won't see the 12 as it's little c at the top of page 322.
I'm sorry. In that case, my mind was not where it should have been. Which witness statement again?
It's the fourth witness statement of Miss Burt, tab 18, and it's paragraph 12C. At the top of the page, you'll just see a little c, page 322.
Yeah, so that is the one that I had in mind, and I remembered it with a different number. Yes.
And I just want to show this to your lordship, because the suggestion is that we've somehow not adequately explained the complaints, and I do reject that. If your lordship looks at the little Roman numerals where the 7 attachments are particularized, you can see the name of the document that's being requested, and in brackets.
Really? Hey. You need not address me further on that.
Okay, I'm grateful for that indication, my lord. And I think your lordship has already dealt with native documents. So that's all I had to say on that, subject to one final point as to the point that's been made about the honest belief in the truth of the document production statements. If your lordship wants to hear from me about that, I will address you. Otherwise, those are my submissions in reply.
Thank you. My intention is, subject to what either of you might want to put to me, not to enter upon whether an unless order should be made now. It seems to me that this is as much a case management exercise as anything else at this stage, with a view to getting the disclosure that should be made to the extent it's deficient. I think that to an extent it is deficient, and I hope within a very short time, give reasons and make an order intended to produce what I think is appropriate disclosure. If that is not done, if that is not complied with, that will be the time to consider what relief might be granted by way of an unless order or in some other way. That is my intention. Ms. Hurst, I appreciate you may want to say something otherwise, so may Mr. Krishna. So what do you want to say about that?
Your Honour, I have conferred extensively with the claimants, and they have given sworn affidavits, which they came before the Chief Registrar of this court and signed, and they say there are no further documents in their possession, custody, or control. And my learned friend just took you through document production statements that were given on the 1st of November, but they have been supplemented by the affidavits where they say they don't just refer to inboxes, but they refer to mailboxes. And they say that the documents that were previously in our possession, custody, or control have been discovered to be in the documents produced by the defendant. Now,
No, I'm not inviting further submissions on whether or not there is compliance.
My apologies.
Further submissions on the course which should be taken from here on.
Yes, sir. Yeah, Your Honour,
I wish to say something about the course I propose. I would have thought it was in your interest.
Yes, Your Honour.
Yes, meaning you don't want to say anything?
Your Honour, I'm in your hands because, again, following the Talim approach, the claimants are only in a position to make a further clarification, but not in a position to produce any further documents. Therefore, if we follow the Talim approach and we are directed to issue a further clarification over and beyond the affidavits, then yes, my lord, but otherwise I'm in your hands as to what directions.
That may well be the result, that no further documents are produced, but there will have been appropriate assurance, if I can put it that way, that the order has been complied with. Ms. Hurst, what about you?
My lord, it is my submission that your lordship could make an unless order today. In my submission, the non-compliance has been extensive, and such compliance as there has been, and in particular the 14th of December affidavits, have been brought about not only after, by my count, 4 rounds of correspondence, but then an application, then submissions made by the claimants that they didn't even need to respond to the application because their disclosure was perfectly fine. They were then directed by the registrar to file those affidavits, and it's only some 3 months after your order that these explanations, deficient though they still are, have been forthcoming. I do suggest that in those circumstances, the non-compliance has been contumacious within the meaning of Deputy Chief Justice Chadwick's remarks in the Roberto Club and Rella case that I cite in my skeleton argument. if your lordship is not minded to make an unless order, then in my submission, there ought to be a very short period of time within which the claimants are ordered to produce such further disclosure as your lordship orders. The reason I say that is because, of course, the procedural timetable is currently on hold because of the delay to the disclosure timetable that we say has been entirely caused by their deficient disclosure. And if they are to be given a final opportunity to make good their disclosure, then that should be a very short period indeed, in my submission within 7 days. And I would also clarify, or wish to clarify in the terms of the order, that all of my client's position in terms of costs would be reserved pending your lordship's further order. But in any event, I would seek the costs of this process and today's hearing. We can either discuss those now or in due course, if your lordship is minded to adjourn and give a further judgment as to the terms of the disclosure. But I would just want to put a marker down that come what may, my clients would be seeking costs.
We already knew that. No, I won't deal with costs now. We'll leave that for another occasion. And I appreciate your point of view, Ms. Hurst, but I will not consider the question of an unless order at this stage. I will defer that, and we will see what happens at the next stage. I appreciate your point about a degree of urgency, and I'm very cognizant of it, and I will do my best to accommodate it.
I'm very grateful, my lord.
All right, well, does that do for now? I hope that I'll be very quick in giving my decision, but I do want to go through things again just to make sure I have not missed any of your submissions. All
Much
right.
obliged.
Thank you.
Pleasure.
Thank you for your assistance, both of you. And what I would do, I think, is in due course adjourn the actual application to a date to be fixed. That'll be part of my reasons, and we can see what happens about that. It can be refixed for any debate over then state of compliance and for decisions on costs and so on, depending on the circumstances. But can be refixed at a time which suits council.
Thank you, my lord. Perhaps in your order, if you could indicate whether your lordship requires any further assistance by way of written submissions in advance of that second hearing. I'm sure we'd both be happy to accommodate that if necessary.
Yes, well, I'll bear that in mind. At the moment, nothing occurs to me. Thank you for the suggestion. Very well. Well, I'll say that so far as I'm concerned, good night. It must be still morning for you, Miss Hurst. And
It is, my lord, yeah. Time for a coffee.
What an excellent idea. Mine might have something harder in it, but all right. Very well.
Thank you, Your Honor.
Good day.